Good morning. Welcome to this morning's presentation of Who Should I Be Talking To, hosted by Cassia. My name is Christine Drasher and I'll be your host today. Before we get started, I have a few housekeeping items. Please turn off your video and audio. Today's presentation will be recorded and a link to view the video and the handouts will be available within a week. I will email all that registered that information once it is posted on our website. CEUs will also be available. At the end of the presentation, I will share directions on how you can get them. And throughout the presentation, we will be using the chat feature to ask questions. If you have any questions, go ahead and put them in the chat and we will answer them during the presentation and also at the end of the presentation. So now I'd like to share with you a little bit about Cassia, which is your host for today's event. Cassia is an affiliation of Augustana Care and Elam Care. The word Cassia means the heart of the servant, and Cassia provides senior housing and services in Minnesota and 4 additional states: Iowa, Colorado, North Dakota, and Florida. We have a wide variety of senior housing options from independent living to skilled nursing care. Today's event is sponsored by a handful of our South Metro communities. I want to thank them all for supporting today's CEU and our future ones that we have coming up for the rest of 2023. The first one is Apple Valley Village. Apple Valley Village has independent, assisted, memory care, care suites, skilled nursing care, both long and short term. They have market rate. They do work with elderly waiver, CADI, and HUD in limitations in their senior housing. And in their skilled nursing, they have private pay, insurance, Medicare, and Medicaid. Currently, they do have 1, 2, and 3 bedroom apartments available in their senior living. All of those are market rate. And for skilled nursing, please give them a call for availability because that does change frequently. Next is Emerald Crest Memory Care. Emerald Crest is a memory care dedicated community in Burtonsville, Minnetonka, Shakopee, and Victoria. They offer 24-hour supervision in 1-level homes that house 12 to 14 residents each. And that 24-hour nursing is available both on-site during the day and on call weekends and overnights. Emerald Crest has been providing memory care for over 23 years, and they do have a unique staged memory care setting where the different houses on each campus are dedicated to 3 different levels of dementia care. Currently, Emerald Crest has openings at each of the 4 locations, private pay, and they do have some elderly waiver, so call them for information on that. Next is the Pines in Ridgefield. The Pines offers independent, assisted living, and care suites. They're in a beautiful area of Ridgefield that is close to kind of all the shopping and the fun stuff in that area. And then is also tucked in a nice little neighborhood that has a beautiful park-like feel. They offer market rate apartments and do accept elderly waiver after 4 years of private pay. Currently, they do have a studio, a 1-bedroom, and 2-bedroom apartments open. Next is Praha Village in New Prague. Praha opened in 2019 and offers independent, assisted, and memory care. They are in a beautiful, up-to-date campus in a growing area. Currently, they have 2-bedroom apartments, 1 elderly waiver assisted living studio, and 2 memory care openings. The Regent of Burnsville is our next featured site. The Regent offers independent, assisted, memory care, and care suites. They are located on beautiful Early Lake and has access to the walking paths on the lake. The Regent is mostly market rate, but does have some limited elderly waiver and CADI. And currently they have a 1-bedroom apartment for independent assisted living and a 1-bedroom care suite. And they do have a female elderly waiver companion suite in both assisted living and memory care. The Rosemount offers independent, assisted, memory care, and care suites. They are connected to the Steeple Center in Rosemount, which is the home to the Rosemount Area Arts Council and the Senior Center. Currently, the Rosemount is market rate only. They have 1 care suite and 2 memory care openings at this time. Our last co-sponsor is Open Circle Adult Day. Open Circle Adult Day has been providing adult day services in the metro for over 40 years. They have 3 locations, Apple Valley, Hopkins, and Minneapolis. Open Circle provides socialization, learning opportunities, stimulating conversations, activities, exercise programs, and entertainment. They do accept private pay, elderly waiver, alternative care grant, CADI, and VA benefits, and also long-term care insurance. Each of their locations does have some openings to take on new members. So give them a call if you have anybody who'd be interested in that. So thank you to all of our sponsors for today. So at this point, now I would like to introduce our speaker, Mary Frances Price. Mary Frances is a shareholder of Moss and Barnett. She has been licensed to practice law since 2005 and has counseled and advised hundreds of clients on their estate and elder care plans. Mary Frances focuses on her practice of serving individuals and families who are establishing an estate plan, revising one, or dealing with the legal, medical, and financial impacts of aging, chronic illness, and disability. She has been accredited to practice before the Department of Veterans Affairs since 2008 and is a wealth of knowledge. So I'm very excited to have her today. So I'm going to pass it on to Mary Frances. You might be muted.
All right, good morning. Can you hear me now?
There you are. Welcome.
Right. Thank you. And Christine, can you just tell me, are you seeing the slides?
I am seeing everything great. Yes.
All right, excellent. We'll jump right in. Well, thanks everybody for joining us today. A little background on the topic. You know, Christine and I have been working together on community education for more than 15 years. And this is a topic that came up maybe 4 years ago, and in response to some demands we were seeing from senior housing professionals, mostly to take a deeper look at, you know, the different fiduciary roles that they were encountering as they're dealing with families that are placing loved ones and making medical and financial and legal decisions. So this was originally developed in response to a request from the senior housing community to just better understand all of the various roles, how they interplay together and overlap in some cases, what the law says. And then one of my favorite expressions is, you know, lawyers talk about what the law says, but then there's what actually happens in practice. Sometimes those two things match up, sometimes they don't. So what I'm going to try to do today is give you the foundational knowledge of what the law says, but then we're going to actually conclude with some case study examples where we'll look at some real life scenarios and talk about how to apply you know, the framework that we're going to talk about. So first of all, let's see if I can advance here. I just want to go through a high-level summary. In general, Minnesota and most states break supported decision-making into 2 broad categories. One is the legal and financial decisions for another person, and one would be the health and wellness. Those are not necessarily legal terms. Those are just my terms of how to kind of break it down into 2 broad categories, but there is a basis for this in law. And on the legal and financial side, you know, here's the checklist of things that you'll encounter when dealing with families, you know, transitioning elder loved ones. We see, of course, attorneys in fact appointed under a power of attorney. So we're going to spend a little more time going into the power of attorney, but the power of attorney is actually the piece of paper. That's a document. And then if I make a power of attorney, the power of attorney of Mary Frances Price, and I appoint my spouse, then my spouse is actually my attorney in fact. The power of attorney is the piece of paper. My spouse is my agent or my attorney in fact in my example. So whoever is the appointed attorney in fact is the one that has legal authority to act on behalf of the principal. So sometimes we see people sign things, you know, Mary Frances POA or AIF. POA is referring back to the power of attorney. More legally correct would be to put AIF because it's referring to the fact that I'm serving as the attorney in fact under that document. We see, a lot of people have trusts, and revocable living trusts are a totally separate entity. And a trustee would be a person responsible for assets that are held in a trust. It can be confusing because sometimes the same person who's serving as the attorney in fact under the power of attorney may also be the trustee, and they may not understand totally, which hat they're wearing at what time. But the best way to think about it is anything that is owned or held by a trust, the trustee is responsible for. So some families that you work with may have a trust set up, and for example, they may have a bank account, an investment account, real estate in the trust. Then the trustee is the person who is responsible for making decisions and distributions. Most people also have things like retirement accounts like IRAs, 401ks, self-employment plans, SEPs, 403bs. Those are special accounts that can never be owned by a trust. So even when somebody has a trust, they have to have a power of attorney to name somebody who can access those accounts that can never be owned by a trust because they're tax deferred. So it can be very confusing to keep these roles straight. For my clients, what I do is I'll actually put together an asset chart that shows everything they own, who's responsible for it, and for their fiduciary, which person has authority to govern those assets. We also encounter in senior services, I'm sure each one of us has, the need to have a representative payee appointed. So you can have somebody with a valid Minnesota power of attorney, with a valid Minnesota trust, but if the Social Security Administration gets wind of the beneficiary lacking capacity, then they may require the family member, even the family member who's under a valid power of attorney, to become the representative payee. And this can be very confusing and frustrating for families because they think, well, why did I do the power of attorney? But the distinction is the Social Security Administration is a federal agency. So they do not have to observe or honor the Minnesota power of attorney because that is a document created under state law. So what's evolved is the Social Security Administration, like the Department of Veterans Affairs, because they're federal agencies, because there are federal funds being distributed for the benefit of a beneficiary, they can come up and have come up with their own rules to vet or determine who is a responsible person to manage the funds on behalf of the Social Security beneficiary who may have limited capacity or it needs support. So the representative payee process may be, and that is strictly limited to those funds. So if it's through the Social Security Administration, once somebody is appointed as the rep payee, they must open up a separate account into which only the Social Security funds would be deposited. They will be responsible for an annual accounting. And so the intention is to keep those funds segregated from other funds, and then to be able to prove to the administration that those funds are being used for the sole benefit of the intended beneficiary. That's what the annual accounting requirement is for. But you can see if somebody has a power of attorney, a trust, and then somebody has to be appointed to manage their Social Security and or VA benefits. The last bullet point is referring to the fiduciary process, which is the equivalent of the rep payee process before the Department of Veterans Affairs for beneficiaries of federal money coming through the VA. So, in some cases, I work with families where we're dealing with all of these roles, right? And they're trying to keep it straight. They've got multiple accounts. They want to write a check from the trust account. It has to be in the capacity of the trustee. They want to take a distribution from an IRA. That's the power of attorney. If there's a rep payee, again, that is strictly Social Security funds. And so, of course, I've got on here, what happens if you have nothing in place, right? You have nothing in place and somebody is in need of help with managing their legal and financial decision-making. And that's where we have a judicial remedy that I think many of us are acquainted with, called the conservatorship, which is, again, a judicial process to determine a person who may be in need of protection to be incompetent at law, and then to appoint someone who would be responsible for managing some or all of their legal or financial decisions. So that's just a high-level overview of the legal and financial roles that we're going to explore a little more. Then we have the health and wellness. So on the health and wellness side, totally separate documents. Sometimes people get confused because they'll say, well, I have a power of attorney and I've been paying all of mom's bills. So what do you mean I can't make medical decisions? I have the power of attorney. But what Minnesota law is very clear that decisions related to where somebody lives, what type of care they receive, refuse, or withdraw, that is a totally separate legal designation. And we have a lot of terms flying around, right? We have healthcare power of attorney, living will, healthcare agent under a healthcare directive. The thing you need to know in Minnesota is, we have one document. It combines a healthcare power of attorney with a living will into one document that is called the healthcare directive. Prior to, I think it was 1996, we had a separate statute for healthcare power of attorney and a separate living will. Our legislature decided to combine those into one. So if you are a Minnesotan over 18 or you're dealing with a Minnesotan over 18, we hope that that person has executed a healthcare directive naming an agent that would be able to assist them anytime after turning 18 through the end of life, and actually extends into what happens with the body after death. Today, I'm also going to explore the CARE Act, which is something that came online in 2017. We'll talk about the interaction of that. We'll look at legal guardianship, which of course is the default if we don't have anybody legally appointed. I'll also touch on the post and also, legal next of kin, because I have circumstances where a family will say, there were 3 of us and we didn't have a power of attorney, and at the end of mom's life, we all made decisions together and it worked out just fine. And that may be true, right? That does happen. Legal next of kin can legally make legal decisions for someone and not require a healthcare directive. But best practice would be to encourage people to get a directive in place in the event that their 3 children don't agree and there results in a conflict. So now I'm going to back up and we're going to go a little deeper into the power of attorney. So, power of attorney is just a document that anyone over 18 that has capacity can sign to the person signing the document is the principal. Okay, so if Mary Frances, if I'm going to sign my document, I'm the principal. It can be used for a very specific purpose, or it can be broad and general. In elder planning, typically powers of attorney are very broad and open because we don't know where, when, or for what purpose they may need to be used. So in general, we would make them, if you've seen the statutory short form, there's a checklist A through M, and we usually select all of the above because in elder planning, the whole intention is, I don't know if I'll become incapacitated. And if I do, I don't know for what purpose my trusted agent might need to use this. So it tends to be a little more open-ended document. Powers of attorney can be immediately effective once they're signed. Our Minnesota statutory form is that type of power where it's signed. It could be used even if somebody has total capacity. There is something called a springing power. Springing power would have language in it that says this document cannot be used unless or until a physician who's examined me has certified in writing that I lack the adequate competence to manage my finances, and then my agent's authority is fully vested. So those are less common, but they are out there. And so if you're dealing with a power of attorney, it would be important to understand, is the agent's authority immediately effective, or do they have to, get a letter or 2 letters of a physician to certify incapacity of the principal? So, just some examples of the type of authority you can grant your agent in a power of attorney: paying bills, signing contracts, requesting distributions from retirement accounts. those are some of the big ones that I see. Also, transferring real estate would be another big one, or like title to an automobile. So really anything that we would do for ourselves, legally or financially, you can draft a power of attorney and give somebody else that authority for you. So I get a lot of questions about a durable power. What is a durable power? Do I have one? Is mine durable? If you're dealing with a Minnesota statutory form, the majority of them are likely to be durable. The language in the green box is taken right off of the Minnesota statutory form. All durable means that the document continues to be valid and usable even after the principal becomes incapacitated, okay? And so again, I've been using incapacity and incompetency, and I just want to pause and make sure we're all on the same page there. Incapacity is a clinical term, and typically that's determined by a medical provider. And so we see in all these legal documents, powers of attorney and trusts, most notably, we see language that says when a provider or a physician who's examined me determines I'm not capable of managing my finances, something to that effect. So I get a lot of questions about who determines if I'm incapacitated. Well, we have to read the document to see how it's defined. But in general, incapacity means that a medical provider is going to render an opinion as to whether or not the principal has capacity. Incompetency is a legal term of art. To be deemed incompetent, that happens before a court of law in either a conservatorship or a guardianship, or a commitment proceeding, which is not something we're going to focus on today. But incompetency determined by the court, incapacity, clinical term, typically a medical provider. So durable just means it endures the incapacity of the principal, which of course in elder planning is typically exactly why we're doing it in the first place. So just a little bit more here about our Minnesota statutory short form. I won't go into a lot of detail other than to say the statutory form is very narrowly tailored. And so while it is a very good document, we all recognize it, it's used all the time. It has some specific limitations. For example, it does not allow for the management of digital assets, which includes anything online. It does not allow for things like changing a beneficiary designation. And so for reasons, and then it also has very limited gifting authority. The gifting authority is limited to $17,000 a calendar year. That's the current IRS gift exemption amount, where you don't have to report if you give $17,000 or less to any individual. And so when families want to broaden the power, they would also have to, in addition to having a statutory form, they'd have to have something called a common law. So if somebody's trying to, for example, make a gift of $50,000 and they're trying to use a statutory form, they may be prohibited from using that power of attorney to manage that type of gift. In which case we'd look at some families will couple that. They'll have both a statutory form and a common law power of attorney. This allows for much broader drafting authority. So this is not a document that's like a boilerplate, right? It looks different because attorneys are drafting it and they're trying to tailor it to a specific client situation. So for example, if I have a client with a $3 million estate and property in Wisconsin and Arizona and Minnesota, you know, we would need to have a broader power of attorney compared to somebody who's living in Minnesota in a senior rental and has a bank account with $80,000 in their Social Security benefit. That client may only need a Minnesota power of attorney and not this broader common law. So it really depends on what the composition of somebody's estate is and also what their income sources are and just the complexity of managing their affairs. That decision is typically made between the client and their attorney as to whether or not they need one or both of these documents. So one thing that's interesting to keep in mind as a senior, worker, a senior professional, is that just because somebody's named in a power of attorney does not mean that they are required to accept the duty. So if your name is on there and you don't want to do it, probably 5 years ago, a friend of my mom's called me. She was living in Chicago and she had a brother that she was estranged from who had apparently been institutionalized in the state of Florida, and a power of attorney surfaced, and he had named her as his primary agent. And she really didn't want anything to do with this. She was dealing with some of her own health problems at the time. The distance would be a challenge. So she was very upset and confused and wondered, was she obligated? And I explained to her, you are not obligated to accept the nomination. However, once somebody does accept the obligation to serve, then they must act prudently, must keep the best interest of the principal in the forefront of their mind at all times, must keep accurate records, and must render an accounting if requested by the principal or otherwise required by law. So it's a big job, right? And so sometimes I think people don't really understand the level of engagement that might be required to serve as an attorney, in fact, particularly for somebody maybe with advancing memory loss who's transitioning into senior housing. And it is, managing all of the legal and financial details of somebody's life. And to the extent you're not available, don't have the time, not interested, it's better to decline, because the law expects a lot from somebody serving in this capacity. Okay. There's liability involved, right? So to the extent if somebody takes the job on, and a simple example would be, let's say I take on the responsibility for someone, and then, their property tax bill comes due and I haven't paid it for 6 months, and now there's penalties and interest. That would arguably be a breach of my fiduciary duty. Now, what if I said, well, I was going through a divorce and I had to get my daughter to college, and, I was sick myself? That may be true, and it may be sad, but if you accept the nomination to serve as somebody's fiduciary, you really have to be willing to follow through. Otherwise, it could result in civil or criminal penalties. So again, as people in the senior worker world, we've seen it all. We've seen really awesome powers of attorneys, in fact, that are super organized and on top of it. We've seen some that are completely chaotic and some that are reckless and criminal. So it's a big job. And so I always try to work with my families to help them, impress upon them. It's not just grab a power of attorney off the internet and sign it to your oldest child because, they're the oldest, and without any understanding of what you're really requesting of that, or, asking of that person. And also the power that you're giving to them, because, statistics are pretty clear. The majority of financial abuse against older adults is committed by generally a family member with a power of attorney. So, just because you have the document doesn't mean it's going to be used correctly. And there's nobody overseeing the use of a power of attorney unless you build in the requirement to have an accounting served on a third party. But even then, there's the opportunity for abuse and misuse. So you really want to be careful about, who you're choosing to serve if you're doing your own directive or document, but also understanding that, we as professionals may be dealing with people with all types of skill set and level of capacity to manage their own life, let alone someone else's with a power of attorney. So even with the risks, powers of attorney are still, the preferred mechanism for designating a fiduciary. And again, the person with the power of attorney is responsible for the management of all the legal interests that are not held in a trust. Okay, so that could be, investments, real estate, personal property, signing legal papers. It can be a very broad power. In general, they're easy to put in place, low cost. Most powers of attorney, depending on if it's a single person or married couple, probably fall, I would guess, between $200 and maybe $750. That's a single statutory short form versus married couple that need both. They can be changed. They can be revoked by somebody who has capacity. They're enforceable and widely recognized under Minnesota law. But they are not being court supervised. So the potential for abuse does exist. And, again, the attorney, in fact, is not obligated. So it is best practice to have a primary, first successor, second successor in the event your primary person, particularly if it's an aging spouse or sibling in the same age group. If you've named that person as the primary, we want to encourage people to think about what if that person has died before or become incapacitated or is otherwise unable to serve, then having the backups is a best practice. So Christine, I'm going to transition to healthcare decision-making. So do we have any questions?
We actually do. Good timing. So I have Jane who asks, do you encourage people to name more than one power of attorney?
Jane, thank you. Good question. And I when I teach community ed, I always say, I'll say to, senior audiences, if you have 4 kids and you love them all equally, should you name them all? Because you don't want to hurt anybody's feelings. Of course, the crowd will laugh a little bit. And some people will look like, yeah, that's a good idea. And others will be shaking their heads saying, no. My practice is, I prefer to have 1, maybe 2. When I was a younger lawyer, almost 20 years ago, and people would say, I want to name all 4 of my kids. And I'd kind of think that's not a great idea, but maybe I would let them do it. Now, when I see what happens in practice, right? If I have a family that's transitioning a parent into assisted living and they have 4 kids named, it creates the opportunity for conflict, chaos, even in really high functioning families with good communication. That's just a lot of cooks in the kitchen. So my professional preference would be 1 or 2. Remember, if you name more than 1 person, you must then, in the document state, must those 2 people act jointly, doing everything together? Yes, signing every check, signing every contract. Or if I name 2, can they act independently? And so they could delegate. And, I was with a new family yesterday, husband and wife, first marriage, 2 common children, both in their late 40s, maybe early 50s. And I said, what's the relationship like between the kids? And then the mom paused and the dad just immediately said, not good. And she said, but I think they'll rise to the occasion for something like this. And I said, okay, let me give you a job description. And I said, the job description is somebody who's detailed, has good control of their own financial life, is available, reasonably available by email, cell phone, and tends to act responsibly in how they conduct their own financial affairs. And then they both blurted out the name of the child that they thought could do that. And it was like, well, this is obvious. That is because they were, she wanted to kind of put them together because she didn't want to hurt anybody's feelings. But the reality is this is work. And it's work that requires a certain level of detail and availability. Doesn't mean you have to live next door. You can be in Chicago, you can be in New York, but you have to be available, you have to be detailed, and you have to be able to honor that fiduciary duty. So that's the long answer for, I really work with my families to try to be very thoughtful about who are we talking about. Just because you have multiple kids, doesn't mean that the oldest should get named. I think it's really, an important conversation to think through. And I am agreeable under certain circumstances to naming more than 1, but then you must take the extra step to specify, do they have to act jointly? And I think if you're being a responsible planner, you're also forcing the conversation about the relational dynamic of those multiple people you're going to name together.
All right, I have another one here. This one is from Jordan. If you have one family member that is a power of attorney, but then you have another family member that provides paperwork that they are now power of attorney without telling the previous power of attorney, is that legal? And which person's decisions should be followed?
So that's a great question, and something you see in high conflict cases where people are struggling for power. It's a sad situation if they're not communicating and we've got the battles of the powers. I think that we look at a couple of things. First of all, the black letter of the law says the most recent document controls. Okay, so the one with the most recent date technically controls, because there's a presumption. It says right at the top of the document, I hereby revoke any previous documents. But the question then becomes, right, for some, did that person execute that? Did the principal execute the new one? Did they understand what they were doing? Did they have capacity? Was it appropriate? And we start to look at details like if they're unraveling a long-standing estate plan or a long-standing relationship with the person they named in the power of attorney, and then somebody else comes in and is trying to exert control. Is it a document they printed themselves off the internet, or did they actually work with an attorney who may have counseled and advised that client and made a capacity assessment? I'll tell you, in my practice and the practice of most of the elder law attorneys I'm acquainted with, we are very cautious about unraveling or undoing or updating. If somebody comes to me and they've been working with another attorney for 20 years or 15 or 5 years, and then a disgruntled child contacts me and says, you know, my sister who's the power of attorney is doing this and that, and I don't agree with it, and I want a new power of attorney, and I'm going to bring my parent in to see you, I proceed very cautiously. If there is a diagnosis of any type of cognitive decline or dementia, I may ask to see certification of capacity to sign a new power. I will absolutely require meeting with the parent or the principal themselves to assess capacity and to discuss their reasons for wanting to do this. But unfortunately, we have a lot of attorneys out there that don't follow these simple steps to really protect the principal. And they may meet with a fired up child and the parent who's maybe pretty persuaded or influenced, you know, unduly influenced. And so we do see, unfortunately, a lot of times where a new power of attorney is executed, it's presented to you, the senior worker, and it may or may not have been executed under correct conditions, but the presumption when it's, if it's done legally, and that's where you may want to refer, you know, out if you suspect any type of, like, it's printed off the internet and it didn't look like it was professionally done, and you maybe know that the principal has some emerging incapacity and is maybe in the middle of family, that it's complicated. But the law says the most recent one controls. The reality is sometimes the most recent one was invalid because it was executed under inappropriate circumstances.
Okay. And one last question, Stephanie asks, is an out-of-state power of attorney legal in Minnesota?
Minnesota will recognize a power of attorney from another state as long as it was executed in accordance with the laws in that state at the time it was executed. And you're thinking, well, how am I going to know that? I mean, I think if it's a valid document, it was done by an attorney in another state, somebody relocates here, in general, our state is going to honor and recognize that. If it looks like there's some sort of glaring omission, or again, you know, it's like a home cooked form printed off the internet, then, you know, it may require a little bit more scrutiny. But if it's a document that was done at a law office in another state, generally Minnesota is going to honor that.
Great, that's it for this part.
Okay. Well, remember our two sides, the legal and financial, the health and wellness. I'm going to transition into a conversation about the directives for healthcare decision making, and then from there go into the CARE Act, and ultimately to our case study examples. So here, you know, I talked about this a little bit earlier. You know, we combine the healthcare power of attorney and living will into one document, the correct document for a Minnesota resident healthcare directive. We also see DNR, DNI forms still floating around out there. And then the POST, of course, is kind of the modern version, if you will, of the DNR, DNI. And about 10 years ago, when I really started seeing POST in families and other lawyers, you know, getting confused about, well, why do we need that if we have a healthcare directive? They both have their place. They're both important. We'll talk about like why somebody would need one or the other or both. First of all, everybody over age 18 should have a healthcare directive. Christine's heard me tell the story. I have a daughter who's going to turn 20 on May 24th. 2 years ago on her 18th birthday, I took her to lunch and I drove her right over to my office where I had a power of attorney and healthcare directive on the desk. And I said, guess what? You want to still live in my house and get financial support? Then you get to sign these documents so that I can still have, you know, the ability to help you direct your care and decision making. And so I kind of joke around. It's not just people over age 65 in the elder continuum. It's anybody over 18. And if you do have young people in your life that are in college and things like that, sometimes we overlook that, but it's also an important tool for them. To be a valid directive, of course, it has to be in writing, it has to be dated, it has to state the principal's name, birth date, and it has to offer some sort of healthcare instruction, even if it's just simply anything I would decide for myself. I'm giving my agent the authority to do that for me. You know, I put a special note in here just to highlight, because sometimes people say, well, I'm not ready to have my daughter, you know, contact my doctor and look at my protected health information. Unlike the Minnesota statutory power of attorney for finance, when it's signed, it's live. The statute for healthcare decision-making is very clear that it's only when the principal's attending physician believes that they lack decision-making capacity to understand the risks and benefits of treatment. That's when the authority of the agent would fully vest. And it's fluid because, sometimes we're working with a patient or a client who has a lack of capacity due to, fractured a hip in the hospital, on meds, develops a UTI. So we see some acute changes in capacity, but then as the person recovers, they may become restored. So capacity can be fluid. It can also be, permanent in the case of a progressive memory loss. So it's, I think, sometimes hard for families to understand that we have a very strong presumption in favor of patient autonomy, meaning that the patient should always and will always be the person who gets to make the decision unless or until that attending decides that they're really not capable of processing and deciding. So I tell people, don't be afraid to sign your healthcare power of attorney, or healthcare directive, because it doesn't mean that you're losing that control of having the ability to direct your care. It's only when your physician believes you're not able to. Okay, so the DNR, DNI, you can include a DNR, DNI preference in your healthcare directive, but it's not a medical order. Okay, a healthcare directive is not a medical order. What does that mean? It means a healthcare directive is signed by the principal and 2 witnesses or a notary. Okay, that's not an order from a medical provider. So that's a big distinction that matters in the delivery of emergency life-sustaining care. But in the healthcare directive, you can express a preference about end-of-life decision-making. But in the 80s and 90s, we saw a lot of DNR, DNI forms that were separate of a healthcare power of attorney or a healthcare directive. And this was developed, I think, correctly in response to the need for long-term care providers and to be able to have a very clear document that is not embedded in a 10-page healthcare document that says what a patient's preferences are if they are not breathing and they don't have a pulse. So it's just intended to be a very efficient way to communicate code preference. So I'm not going to spend a ton of time on this, but I just wanted to draw the distinction between, we still do see separate DNR, DNI orders. You can also incorporate your preference about that into a healthcare directive, but a separate order would be required if somebody wants to refuse life-sustaining treatment. And I'll give you a more specific example when we transition to talking about the POST here, because really this is the document I'm seeing so much more frequently. Now, you may recall I said, my opinion is everybody over 18 in Minnesota needs a healthcare directive. Not everybody needs a POST, but the purpose of the POST is to allow the patient and the medical provider to communicate end of life treatment preferences in a 1-page, easy to read document. I see it used when patients have chronic health conditions, terminal conditions, or if they just simply, during the pandemic, I had a client in her late 90s, totally high functioning and healthy, but she got to thinking during periods of isolation, what if I die at home? And if somebody comes in and finds me, I do not want CPR. So she, got a POST and posted it on her refrigerator and made it clear. Now, if she had just put her healthcare directive on the refrigerator that said, I don't want any life-sustaining treatment, that would not work for an emergency responder to not deliver life-sustaining treatment. She required a medical order. So that's, I think, a very important distinction to help our families understand, and why I'll educate my families that if they're in senior housing settings or if they have really strong preferences about end of life, then a POST may be a good thing to add in addition to the healthcare directive, but the healthcare directive is not a medical order. So before I transition away from DNR, DNI, and POST, Christine, I just want to check in and see if Any other
Yeah.
questions?
And just one question, you might have already answered this, but does the healthcare directive need to match the post?
That's a great question. And ideally, yes, right? Ideally, yes. Although patients can change their mind. I think where it gets tricky is here. If somebody said in their healthcare directive, I'm full code, but then they're hospitalized and they, the patient, later complete a post that reflects something different, then I think, that happens and that's okay. Where I think it gets a little trickier is when you have a healthcare directive that says full code and the patient is totally incapacitated and then their agent is asked to complete a post. And if the agent believes that the preferences under the current circumstances would be not to be full code, then there has to be a conversation about whether or not they can deviate from the instruction in the healthcare directive. I think that it depends on a number of things: the condition of the patient, the age of the healthcare directive, what has happened since the healthcare directive was drafted to where the patient is in their healthcare journey now. I mean, certainly there are a lot of times where it really makes sense to change that, but it's a gray area when you have a healthcare directive that says, I want this, but then 15 years later, maybe full code isn't appropriate anymore and a post would. So again, what the law requires, obviously the law would like to see uniformity. What I see in practice is sometimes there's a deviation. If it's the patient directing it, it feels, a lot more secure. If it's the agent that's directing it, it still may be appropriate. It's just something that needs to be given a little bit more thought, I think.
All right, that's it for this section.
Okay. So just to kind of review, we talked about the healthcare directive, the DNR, the separate DNR, DNI orders in the post, which are kind of similar. To throw one more thing in the mix, in 2017, we had the introduction of the Caregiver Act, which was legislation heavily promoted by ARP, with the intention of improving transition plans for patients after they're being discharged from the hospital. So this offered the opportunity for someone to name a person that they would like to be able to be notified and receive discharge or transfer instructions on behalf of the patient. I think one of the things we saw immediately with the introduction of the Caregiver Act was that there was a disconnect because people didn't always give the name of the person who was named as their primary healthcare agent. And that presented the opportunity for some conflict and confusion. So the designator caregiver is not, if you can picture this, right? 85-year-old woman transitioned to the hospital with UTI and acute delirium is asked, who do you want to designate under the Caregiver Act to receive instructions about your discharge plan? Woman has an adult daughter living in Chicago named as a healthcare agent, but she's recently developed a friendship with the granddaughter of a neighbor who moved into her South Minneapolis house. So she thinks of this person because she's been coming over and befriending her and helping her with tasks and chores. This is an actual case I dealt with. And, the caregiver that was designated wasn't required to provide any care, but was willing and able to help this person transition back to her home with instructions. She didn't have any legal obligation or any authority, frankly, to make decisions or look at protected health information. It was really just intended to be information regarding discharge orders and transition plan. But in the case that I was referring to, what happened was this was a person who was actually grooming the woman to commit some abuse, and it had started financial abuse. And so unfortunately, it was just, kind of an opportunity where she named this person as someone who was going to help her transition when she was in a very vulnerable state. And for whatever reason, her healthcare agent daughter was never notified. The patient was thinking, well, I don't want to bother her. But what the result was, of course, the instruction was given to somebody who was really, not well intended. And so it created a problem. So I think to the extent we can educate our families that if you're going to be naming someone under the CARE Act, Ideally, it would be somebody who's also named in your healthcare directive, because they also have that legal authority to make decisions, to look at protected health information and so on. So now I'm going to just transition into some of our case studies. So here I've got second husband versus daughter. The scenario is patient is married to the second husband of more than 20 years. She executed a healthcare directive in 2012, naming her daughter, who's a nurse, as her agent. Husband, however, is the person who's always at the medical appointments. He's always the first in attendance, often transporting her to hospitalizations. During a recent stay in transitional care, patient was not capable of making a decision about where to transition after her TCU stay. And husband and daughter attend the care conference together, but seem to have a pretty strong difference of opinion about where to move the patient. So here, my question I pose to you is, who gets to decide, right? Who gets to decide? Husband, arguably legal next of kin. He's the one who's present all the time. Daughter, let's say she lives out of town. But the presumption by naming somebody in that healthcare directive is so strong that it's clear here that the daughter has the authority to decide where mom's going to live and what level of care she's going to receive. She can seek input from husband, but ultimately, if she is named as the healthcare agent, that authority supersedes his status as a spouse. So if they're in conflict, hopefully they're able to resolve it. But just to kind of illustrate how strong that presumption is in favor of the named agent, daughter would have the authority here to make the ultimate call. Okay, so I think this is, again, I wish I made these up. I didn't. These are all based on my practice over the last, however many years, things that I've observed or had to deal with when working with families. So here's one where daughter was the healthcare agent and son was the power of attorney. Okay, so remember back at the beginning, the healthcare agent is in charge of health, wellness, the body, medical decisions. Where is mom going to live? Son is in charge of all of the money, right? Has the power of attorney. So he's, managing the retirement accounts, the bank accounts, in essence, the income, because it's coming into the bank accounts. So here we have a resident who's been in assisted living for about 6 months. Recently, daughter, as the healthcare agent, was correctly notified. The staff was noticing changes and requested an evaluation for level of care. Resident was found to be in need of additional services to ensure her health and safety. Daughter agreed to the increased level of care. Son receives invoice after the first month following the new level of care, and he questions the increased cost and some of the services and says he refuses to pay. So what happens here, again, these situations are so tough, but the son's job is to pay valid debts and expenses, okay? He did not have the authority to make a decision about whether or not the increased level of care was valid. That is clearly the daughter's role as the healthcare agent. So if she had a care conference, if she made that decision based on the information that was presented to her, and then it would arguably be a valid debt, and as the fiduciary, he would be responsible for paying that. Does he have the right to question it? He can question it to make sure that it's valid, that she received the services, but he is not able to decide if the services are necessary. That would be the job of the agent. He can just decide, is this right? Did she actually receive this? So that's something that the attorney in fact would do, is make sure that she's receiving fair value, make sure that it's a valid debt, but he can't really question whether or not it was a good decision for his sister to consent to the increased level of care. Okay, so it's a subtle distinction, but an important one, particularly when we're trying to figure out these different roles that family members may play. So our next case study is husband is the healthcare agent and daughter is the attorney in fact. So patient living in memory care, recently certified for hospice after 3 years of private pay. Husband determines he just wants to bring his wife home because he's just sick of paying $10,000 per month and she's close to the end of life. So he's decided she'd rather die at home. Daughter is the successor agent on the healthcare directive and the power of attorney. She reports that mom and dad, although together, have hated each other for years. She's very worried about dad's resentfulness towards mom on the money he's had to spend on her care for these years. And she's worried that he's making the decision not simply because she would prefer to die at home and that's more comfortable, but just because of the money. And she's very concerned that she would be inadequately supported even on hospice, because in her current assisted care community, memory care, she was receiving a pretty high level of support. So dad gets very angry and tells the provider that they are barred from giving any further information to the daughter about the health care. And so the question here is, who gets to decide, and what, if anything, can be done? Okay. Again, real life case that I was involved with, very sad. Because of the being in memory care instead of a nursing home, there is greater control by the family to remove the resident. They should obviously, ideally, you'd want to have adequate supports in place in the transition plan, but here dad was able to at least say that he had an adequate plan in place using family members and other outside support. Obviously the hospice benefit as well, but that was rather limited compared to the level of care this person actually required. He clearly gets to decide where she's going to live as her primary agent. What, if anything, could be done? Well, in this case, the dad had his own advancing memory loss. So the daughter was confronted with, does she petition the court to try to get him removed as the primary healthcare agent and have her authority vested as the successor, under the premise that he really wasn't making decisions that were in the best interest of mom, but he was being influenced by some self-dealing conflict of interest issues, including the financial burdens, also the risk of him not really being able to provide the appropriate level of care. It was a pretty tricky situation to be involved with, but there are a lot of different ways a scenario like this could go. And we hope that families can collaborate and come to an agreeable solution that keeps the resident at the correct level of care, so they're not putting the health and safety at risk. But sometimes people are willing to put themselves or others at risk because they perceive they can't afford to do anything else. Okay, so next case study, resident with a revocable trust and an IRA. IRA is individual retirement account. Individual retirement accounts are something that people generally fund. Like if you're employed and you have a 401k or a 403b with your employer, and then you leave employment or retire, what happens is people will typically take their portion of that 401k plan and roll it into an individual retirement account, which is governed differently under federal law than when you're part of an employer plan. So IRAs are dollars that we have each contributed and never paid a tax. And then we hope that it grows, and the growth has never been taxed. But once we turn age 72, we are required to start taking minimum distributions annually. And so here we've got a resident in memory care with a revocable trust and investments in bank account. Trustee is son number one. Okay, so the trust is holding investment accounts and cash accounts in the bank. Resident also has an IRA, and resident has a power of attorney naming son number two as the attorney in fact. Okay, so again, the trustee son, she thought this was great. You're in charge of the investments and bank account. Son number two, you're in charge of the IRA. So son number two refuses to provide any distributions for care. Son number one says that the trust requires that retirement assets be depleted before trust assets can be used to pay for care. So we have these two sons fighting. Son number one is alleging that son number two changed the beneficiary designation to make himself the sole beneficiary of the IRA. And that's why he's refusing to make any distributions, because he's actually trying to preserve the asset for himself. So what happens here? Again, high conflict situation, potential self-dealing conflicts of interest. This is likely going to be a scenario where attorneys would get involved to try and resolve the matter. But what I wanted to illustrate for you was the difference between the trustee being responsible for things in the trust and the person named in the power of attorney being responsible for those retirement assets. They're different roles, and a lot of times people name the same person, but not always. And it's just important to understand when you're engaging with families and they're trying to access resources, like which hat are you wearing? Are you under the power of attorney? Are you the trustee? Is it a rep payee account? Or are you under conservatorship, right? These are all different things that require different proof of authority to act. Okay, so moving on, next case study, incapacitated resident with no family, right? I think the previous term that we used to use, I don't know if when it fell out of favor, was the unbefriended elder. I'm sure many of you have heard that term, the unbefriended elder. And now I understand that the modern term is solo, a solo senior. Kind of, that's our name, that's our term for somebody who just doesn't have family. Maybe they were never married, didn't have children. Their siblings have died before them. We have a resident who can't manage legal and financial decisions. There's no family. There's a neighbor appointed as the representative payee. And so the question is, what can this person do? And can they get access to other accounts to help the resident pay for care? And so I had a situation where a rep payee neighbor, just kind of a friend and a good citizen, was helping this person manage their Social Security benefit. But remember, the rep payee designation is limited only to that Social Security. So in this case, to the extent that the person, we first have to decide, do they have capacity? Could they sign a power of attorney? Could they give this person or someone else authority to act under a power of attorney? And if there is no capacity, we're probably looking at a conservatorship to get the assets under management so that they can be used to help pay for care. Who petitions for a conservatorship? Sometimes it's the senior housing community. Sometimes it's somebody in the, family or the neighbor. So it would have to be somebody with a statutory interested basis. But there's no one right answer, but there is kind of a hierarchy spelled out in the statute of who can petition to become a conservator or a guardian. So I think that's my last example. I'm happy to take any additional questions or circle back to any content that you wanted me to clarify.
I don't see anything in the chat, but if anybody does have any questions or anything, please enter it now. I see Mary Francis's information is there if you want to contact her directly. And I'll have that on the handout as well that you'll get afterwards. But I'm going to go ahead and go back to my screen, Mary Francis.
Okay.
And we'll just give a minute or two to see if anybody has any questions. Okay, let's see. We do have one from Sharon. When does the power of attorney authority end?
The power of attorney ceases at the death of the principal. So the minute a death occurs, the power of attorney is invalid and is no longer usable. It is only a designation during the lifetime of the principal.
All right, can you provide examples of when families or people may pursue guardianship, conservatorship, even when these legal forms are in place?
Sure. I had one recently, just maybe last week, and it was a situation where even though there was a power of attorney and a healthcare directive, I'll give you the scenario. It was a father living in the community, and he had an adult son who had been in his basement for about 15 years with some mental health and other issues. The other son had a power of attorney, Minnesota power of attorney, and dad was hospitalized, went to rehab, and after rehab was going to be discharged to skilled nursing. And he really had no other assets other than the house. So an application for medical assistance was made immediately, and his house was going to need to be sold, making reasonable efforts to sell within 6 months. But we had this resident in the basement who was, we needed to evict because he was not voluntarily willing to leave. So we had to, even though we had a power of attorney and a healthcare directive, we had to petition for a limited conservatorship to get the authority to commence an eviction proceeding. More commonly, I'd say, what I see is when we have healthcare directives and powers of attorney where maybe the primary person is maybe not acting in the best interest of the agent, or someone else feels they may not be acting in the best interest, or maybe they have their own advancing memory loss or health problems which would compromise their ability to continue to serve as the primary agent, but they're not voluntarily resigning. So we're in a situation where how do we involuntarily remove somebody who's in a first priority position? And that would require, a judicial proceeding. So that's kind of where I see it. And sometimes I also see it where, we have two people named as co-healthcare agents with equal authority, and they can't agree. And they both think they're right. And they both 100% they believe they knew what the principal wants or wanted. And so they're in high conflict, and that a case like that would possibly be resolved through a guardianship or conservatorship proceeding where we ask the court to make the ultimate decision. So even though there are those documents in place, sometimes they don't work, or they fail for some reason. And it usually has to do with concerns over the person who's appointed not doing a good job or carrying out their required duties, or someone believes they aren't, but maybe they are. In any event, there's a conflict of opinion, and that results in, a judicial action.
Okay. Let's see here. Okay. Is it always best for the resident to sign the contract if they are able? Oftentimes the attorney in fact prefers to sign, and I'm assuming that would be contracts for housing, assisted living contracts, maybe?
Either one is valid, right? If it's my parent and my parent has capacity to sign, I'm going to say, Mom, you sign. This is your deal, right? If my parent doesn't have capacity, I can sign as, attorney in fact. They have equal authority. But if I'm the adult child and I don't want to be the responsible party, and I just want to, I'd have to make it very clear I'm signing in my capacity as attorney in fact, and then it's the equivalent of signing for the parent. So it's really kind of, preference. I think sometimes what happens is kids are, getting involved in the, management of their parents' affairs, and they get very comfortable and fluid and used to kind of doing everything because maybe there's some diminished capacity, but they could still sign. So I think there's no one right answer, and legally the effect of the parent signing, the effect of the attorney in fact signing are the same.
Okay. So Jane has a question. So the guardianship conservatorship would cancel the other roles. Is that right?
Right. So if the court were to order, like, for example, a conservatorship, let's take the case I just gave you with the eviction. It did not invalidate my power of attorney because I sought a limited conservatorship for the purpose of evicting. So my power of attorney was still intact. In other cases, it may invalidate the previous document. It's specific to each action. And in guardianship and conservatorship, there's like a menu of things that the guardian or conservator can be in charge of. And not every conservator, for example, gets the full menu. They may only have limited scope of the conservatorship. So you really need to look at the conservatorship document. It may not completely supplant the previous documents. It depends on what the court order specifies. And if the court order specifies something narrow, and then there's another document that covers other decisions, they may both be valid for different reasons.
Okay. What people would have the authority to change beneficiaries for a person without capacity? The conservator, common law power of attorney?
Common law power of attorney, certainly if it has the language that says this document can be used to change beneficiary designations, you have to read the document and see if it allows for that. It may allow for changing a beneficiary designation to conform it with a revocable trust. So you have to really be clear on what does it say. If it's broad, yeah, I can make any changes to my beneficiary designations whatsoever, then that's a pretty open-ended language. But some powers of attorney say can only alter beneficiary designations to conform with my revocable trust. So you'd want to look at the language in the common law. And with regard to conservator, again, it's going to depend on what the court order provides. And in some cases, we may petition the court to seek permission to alter a beneficiary designation to conform with an estate plan. But, you know, in general, you'd have to have that authority specifically articulated in a court order or a power of attorney.
Okay, got another one. Good questions. It's fun to see these. When a person who no longer has capacity is now needing to apply for medical assistance, and there is life insurance policy that the attorney in fact is wanting to change themselves as the beneficiary to a burial account, is the attorney in fact able to change the beneficiary? There's no other documents in place.
So again, I would go back to what does that power of attorney allow the attorney in fact to do? You know, sometimes if it's a life insurance policy that we can cash in and then use the cash to fund the prearranged Medicaid qualifying burial, you know, that may be permissible. So you always go first to the power of attorney and see, does it allow my agent to do this? And if it does, then they may be able to. But if you have somebody who's named in a power of attorney, and if it's a life insurance with cash value, I'd be looking at, can they cash it out and, you know, pre-plan and pre-arrange and prepay that Medicaid qualifying burial plan. I'm not clear on what you mean by the beneficiary, because if you're cashing it out to pre-fund a burial plan, the beneficiary is the cremation society or funeral home, and the next one in line is the state of Minnesota, right? So there's not going to be anything left for the family under that circumstance.
Okay. Well, we will end here. No more questions. Just some great comments, how informative this has been, and appreciates all the information. And thank you, Mary Frances. You're always a wealth of knowledge. I learn something all the time when I listen to you, so appreciate it. For those who need to receive a CEU, I'm going to have you go on to this link, and I'm going to have you do a quick little survey to receive that. And I put it also in the chat room, so if you want to just copy and paste from the chat room, you can do that. But just have a few questions, and then a way that you can put your information to receive that CEU. So so make sure you do that if you need it. And then I just want to do a quick little friendly reminder to mark your calendars. Our next CEU is on June 27th. It is virtual on Zoom again. It's dementia friendly environments. We'll have Teresa Klein, who's a dementia consultant, who will be talking about, you know, what are some things to consider in your dementia unit or the environment that you work that can make it dementia friendly. So I'll be sending out probably information on that to everybody who registered today, just as informative, probably at the end of May here, to how to register if you're interested in that. So all right, well, thank you, everyone. And with that, we'll end our presentation, and we will see you next time. Thank you.